What happened to his company?
ले वो प्लेट आपने
Oh no. Company got it.
he told him to get on the new console.
Will he appoint a new council?
That home में not yet.
Will he appoint a new council?
No go away.
अरे वहाँ पर ही है, बहुत अच्छा। You have to-
See. Will you?
Defense counsel has Chhatrapati has entered appearance to the accused on 31/17/2010. Thereafter, he appears guilty. Court has noticed a very strange practice of the counsel. After attending appearance in a case involving offense under section 302 IPC, abruptly, the defense counsel stops appearing. They have neither withdrawn their power nor intimated the counsel, nor intimated the court the reasons for the absence. Charged in the instant case of claim on 30 October 2018, till date, only 2 key accused have been examined. Matter cannot be kept pending for trial due to non-appearance of the defense counsel. The accused shall be provided legal counsel. Copy of this order shall be communicated to the Secretary DNS fixed for appearance of the legal counsel. Prosecution shall take steps to summon witnesses only after the defense counsel had entered, only after the defense counsel enters appearance.
All option. Win defense.
Another prosecutor. Another additional prosecutor. That's the fact. All the accused persons are absent without any step. Defense counsel is absent without any step. this food was issued. Available warrant against the accused person. There is no report on the available warrant issued against the accused persons. This is another case where the counsel is absent without any steps. A refix for report on the bailable warrant issued against the accused persons. Yes.
Itu boleh tidak?
Yes.
Witness is the who you see, right? Doctor.
Who?
From
where?
From Jammu.
Okay.
And the list number 8.
Yes. What is this case?
Case of case number 6.
All right. Any witness?
No witness, Your Honor.
All right. Accused. Endelis Labare present along with defense counsel Sri K. Lansang. Additional prosecutor S. Chansang present. Prosecution shall ensure that witness is present on the next date fixed. Prosecution to take steps to summon witnesses. Yes.
Yang time dekat.
Yes. Compliance of what?
Accused is under treatment at 3 months.
And this court has been informed by letter dated 27 November 2025 issued by Superintendent District Prison and Correctional Home that the accused is undergoing treatment at Mimans. Medical status report issued by Dr. S. D. Lingwa is appended along with the communication dated 27 November 2025, as per the medical status report, the accused is not fit to stand for trial. The accused shall be produced before this court after being discharged and found fit to stand for trial. Yes.
Salam bikin stamp.
Yes.
Brother-in-law of the accused informed me that he was suffering from diarrhea. Not yet.
File an application.
Yes, I'm finding it.
This matter is fixed today for examination of the accused under section 313. Defense counsel has filed a petition number so and so, supported by an affidavit inter alia, praying for dispensing the personal appearance of the accused on the ground that the accused is ill. Examination of the accused under section 313 is deferred till next date fixed. Yes.
Kamay lang pala.
The condemnation application did you file,
Yes.
You allow show first stage.
We'll continue. The petitioner has preferred an appeal under Section 101 of the Juvenile Justice Care and Protection Act 2015. Then you write down the JJ Act. Hereinafter referred as JJ Act 2015. Against the impugned order dated. What is the impugned order? Where? Why don't you write in the cause title? Against the impugned order dated 25/9/2025, passed by the JJB Board, July. Section full stop. Section 101 of the JJ Act 2015 provides a period of limitation of 30 days, which commence from the date of the order for preferring an appeal. For preferring an appeal against the order passed by the board. The petitioner has preferred an appeal after delay of 32 days. To stop. Delay in filing an appeal can be condoned if the petitioner advances a cause which constitutes a sufficient cause. Full stop. The learned prosecutor present before the learned prosecutor is so next paragraph. Learned prosecutor present before this court submits that you'll file objection. Submit that you would not file objection to the condonation petition. Heard learned counsel for the petitioner, Srimati. So heard learned prosecutor. So the petitioner has assigned the reason for not preferring an appeal within the stipulated period in para 4 of the condonation application. Full stop. The petitioner has stated that appeal could not be preferred in time, inasmuch as the petitioner did not have financial means to engage a counsel promptly. This court finds that the financial disability should not come in the way of the parties to agitate the matter on merit. if the full stop, if the petitioner was thwarted to approach this court due to financial disability, in the opinion of this court, it would be a good cause for condoning delay. And the cause would come within the ambit of sufficient cause. Delay of 32 days in preferring the instant appeal and delay of 32 days in preferring criminal appeal number 1 of 2025 is condoned. This condonation application is allowed and disposed of. Yes. 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 Now tell me, what is the case?
The fact of the case is that on 15/9/2025, Your Honor,
Hmm.
the FIR was lodged against.
What is wrong with the impugn order?
Your Honor, on the day that the CCIL was produced before the JJB, Your Honor.
See, when the CCL was arrested, they did not know whether he was juvenile, whether he is juvenile or not. The police found out during investigation. Initially, he found out that he was 17 years old, isn't it? Thereafter, on further investigation, after seizing the EPIC card, he was found that he's aged about 19 years. The investigating officer informed the board that he's not a juvenile. Accordingly, the board passed an order that he should be tried as an adult, not as a juvenile. Now, this EPIC card was issued by the Deputy Commissioner based on the certificate of Baptist, isn't it? So what is wrong?
The CCIL, Your Honor, they are laymen. And during that time, Your Honor, that time it is during the election, Your Honor, and they were excited by the election, Your Honor. So they were asked to take the picture. They did not have the voter ID, Your Honor, except the
Matter is under
roll, Your Honor.
investigation.
Your Honor, they don't have in the possession.
The matter is under investigation.
Yes, yes, sir.
Yes.
But the CCIL, Your Honor, they don't have the voter ID in their possession, Your Honor, and they don't know that.
You are on bail.
Yes, Your Honor.
How are you aggrieved?
I was on bail on 3rd 11/25.
No, how are you aggrieved by this order? What is your grievances?
Your Honor, surprisingly, on the 25, Your Honor, 25/09, Your Honor, when he was produced before the JJB, Your Honor, on that day, the IO intimidated that he has the voter ID, Your Honor. First of all, Your Honor.
We understand your point. The matter is under investigation, isn't it? So how are you aggrieved by that? You are on bail. So what is your grievances? If a charge sheet is filed, then you agitate the matter before the court. You raise the question of juvenility.
Your Honor, the court allowed the prayer of the IO, Your Honor, solely rely on the age of the on the voter ID, Your Honor. They did not follow the guidelines mandated on Section 15, Your Honor. There is no preliminary assessment is conducted, Your Honor.
Why preliminary assessment when you are aged about 19 years? On the date of the commission of the offence, you are 19 years old. There are sufficient evidence to show that you are 19 years old. There is an EPIC card. EPIC card was issued based on the Baptist certificate issued by the church. And what is the basis of you being 17 years?
Your Honor, the petitioner back to state that, Your Honor, her son is 17 years old, Your Honor.
You may say, but what is the evidence that you are 17 years?
There is no documents to prove,
Then?
Your Honor, as the CCIL doesn't have any birth certificate or.
The investigating officer has seized the EPIC card, your Baptist certificate. What do you have to show that you are 17 years?
There is no document as
Then,
such, Your Honor.
just because you say that I am not 19 years, we will go for an inquiry under section 94. Why?
Because, Your Honor,
Investigating officer made a mistake by saying that you were 17 years when the date on the date of the commission of the offense. Well, after thoroughly investigating the matter, they found that you are 19 years old, supported by some documentary evidence.
Honor, as you're aware and well aware, Your Honor, EPICAT is not a conclusive document to determine the age of the CCIL, Your Honor. So I humbly pray, Your Honor, may this petition allowed and set aside the order, Your Honor, passed by the
Why?
SB, Your Honor,
Why will you set aside the order passed by the board?
to conduct the preliminary assessment, Your Honor.
Why preliminary assessment? Read section 15. What are the preconditions for invoking the power under section 15? One, you should be between the age of 17 to 16 to 18. One. And then the alleged offense should be a heinous offense. What is heinous offense? Heinous offense are those offenses where the punishment is more than 7 years. Why should we order for a preliminary inquiry? Or why should we order for preliminary assessment? Why? If you are between the age of 16 to 18 and the offense is heinous, it is for the board to take a call, and it is they are bound to conduct a preliminary assessment. If they decide that you should be tried by an adult court, then they will conduct a preliminary assessment and take a decision whether you should be tried by the adult court or by the board. But where is the question of preliminary assessment? Here there is a dispute with regard to the age.
Yes, Your Honor, but the petitioner here, Your Honor, her son is 17 years old, Your Honor.
But what is the basis on which, if somebody who is 40 years old and he just comes and tells before the court that I am 16, we will say no. Just because you said you are 16, now we have to go and conduct inquiry with regard to the age and we have to determine the age. If this is how we go, then everybody will say that I am juvenile. One hand, the prosecution, not only the prosecution, we have not come to the stage of the prosecution also. The matter is under investigation. Initially, the investigating officer found that you were aged about 17 years on the date of the commission of the offense. So you were remanded to juvenile observation home. On further investigating the matter, they found your EPIC card and your age was 19 years in the EPIC card. You are exercising universal adult franchise. You are casting vote. Perhaps you may have also casted vote. You have enjoyed all the privilege of being major, but for the purpose of this case, you become minor. Have you applied for the cancellation of the EPIC? And then?
Your Honor, the IO, Your Honor, has submitted the order mechanically, Your Honor, without mentioning the serial number of the voter ID, Your Honor.
Do you dispute that that voter ID is not yours?
Yes, Your Honor.
You dispute?
Yes.
Where is that voter ID?
We do not have it in our possession, Your Honor.
That voter ID card is not yours.
No, Your Honor. It's not in our possession, Your Honor.
No, not being in possession is one thing, but it does not belong to you is another thing. Do you dispute that voter ID card is not yours?
Yes, Your Honor, because we don't see it. They don't give us a copy as yet, Your Honor. So,
Why should they give the copy to you? You'll get all the copies when they file the final report. At this stage, what is your grievances? I don't understand. Read the impugn order. What is the problem? What is problem with the impugn order?
the order here, Your Honor.
What is wrong with the impugn order?
Because, Your Honor, first of all, he is 17 years old, Your Honor. And
Yes.
later, they said that with the ID, Your Honor, they said that he is 18, 19 years old, Your Honor.
Yes.
But as a mother, Your Honor, the petitioner here, she is.
No. We don't go into those matters. How can we attach any conclusion when the matter is under investigation? Read the impugn order. No, I don't understand that. What is your grievances? How are you agreed by this order?
Your Honor, here I only pray, Your Honor, for the to send him for determination of age, Your Honor. Whatever the report will be, we will satisfy with all, whatever the report, Your Honor. Because there is no birth certificate and no school certificate, Your Honor. The last option is determination of age, Your Honor.
You make a prayer before the court. The matter is under investigation. You can challenge it, isn't it? Are you sure this matter will go for charge sheet? The matter is under investigation. How are you aggrieved? You are on bail. So which part of the order you are affected? Which part of the order? How are you affected by the order which you have
Yes,
challenged?
Your Honor, here,
Ah.
Justice Ayal, he's 17 years old, but they already agreed that he will be sent to district prison, Your Honor.
He's on jail. He's in jail.
He's on bail, Your Honor.
Then where is the occasion of he being sent to district prison? You mean to say I can understand that he was released on bail under section 12? He was released on bail because he was juvenile. It is mandatory for the accused to be released on bail. Now, after he was declared to be a person who is adult, then the court ordered that he should be taken into custody. Any such orders is there?
In this case, the CICL has declared he was released on bail by the magistrate court, not the board.
Yes. So you are on bail.
He's only on bail.
So what is your grievances? No, you see, if you need to be agreed by the order, isn't it? What is your grievances? How are you affected by the order? One, then we'll look at the legality of the order. How are you affected by this order? Passed by the board, how are you affected?
Because, Your Honor, first of all, they told that he was 17, and later they said he was 17, Your Honor. And plus, Your Honor, the voter ID they submitted mechanically, Your Honor, without mention any serial number or whatsoever, Your Honor. And also, Your Honor, Your Honor, they did not follow, Your Honor, because there is no birth certificate and school certificate, Your Honor, and there is no determination of age before they send it to the
impugn order.
Send it to the prison, Your Honor.
All is good, but how are you aggrieved by the impugn order? What is your grievances? How are you affected by this order? Please tell us, how are you affected by this order? Then we'll look at the legality of this order. How are you affected? Please read the impugn order.
From the mother, Your Honor.
Whichever part you want to read. Okay, read. Just read hurriedly.
In bill application made by petitioner through
Where are you reading? Annexure 2, page 8. Please read.
as per the prayer, Your Honor, on perusal of record, it appeared that one person by the name Lilan Lamari had been apprehended and by order dated so by learned member of this board. The person is in position projected to be a CCL, was thereafter sent to observation home, pending inquiry investigation. The matter herein concerned as an offense of trespass, theft, and criminal breach of trust, which resultantly makes the offences non-bailable, and Lilan Lamari appear to be in compliance alongside two other persons who have been arrested and has remanded to custody. The learned member, JJB, had ordered that Lamari be sent to observation home, Boys Your Honor, Shillong, for reason that it was reflected that he was 17 years old. at the time of the commission of the offense, coming into conflict with law, although there was nothing to support such claim, Your Honor, either by way of birth or baptismal matriculation certificate extra. However, in due course of inquiry investigation, it was found that Lilat Milamari had already attained 19 years old as per his electoral roll, which has been countersigned in original by electoral registration officer. Mupia Assembly Constitution, West Jaintia Hills District on 22nd 9 2025. A printout of the same along with a copy of his baptismal certificate has been submitted along with the prayer and the name of Lilatmi Limre as per record and per electoral roll and that of his parent appear to tally with such certificate. In view of the above development, the nature of the allegation leveled against the accused, and as it appeared that he was not a CCM at the time of commission of the offense, this board is inclined to allow his prayer to sail through. In effect, such others, the IO is to coordinate with the SJIU, West Jaintia Hills District, and that on at least one female police personnel shall accompany the IO on the journey to secure the retrieve Lilatmi Limari from the observation home, Shillong. LCPO, West Jaintia Hills District, shall also be informed of the same and shall accompany the arresting personnel as well. This board is also informed by the IO and one family member of Lilat Limri is also present today. At least one of such family member shall also accompany the arresting personnel in the journey and back thereafter. All care shall be taken not to disturb the CCL at that home. That apart, the IO shall follow all relevant guidelines issued by Honorable the Apex Court from time to time in this regard. Copy of this order.
Yes, what's wrong? What is wrong?
The electoral roll wrong.
No, what is wrong with the order?
There is nothing to support, Your Honor, for the claim that he is 19 years old, Your Honor.
The election card,
Election card, Your Honor, there is no serial number mentioned, Your Honor.
your Baptist card, certificate.
Your Honor, at the moment, Your Honor,
What do you have to show that you are 17 years?
we don't have any documents, Your Honor.
Then?
Therefore, Your Honor, I pray before the court, Your Honor, to allow the court to direct the board, Your Honor, to conduct the preliminary assessment. Your Honor.
Preliminary
To determine
assessment?
his age, Your Honor.
Preliminary assessment.
Yes, Your Honor.
Why?
To determine his age, Your Honor.
Why should we ask the board to determine this age?
For authentication test.
The matter is under investigation. If the investigation is concluded and you are held to be 19 years, you challenge it. Wherever the charge sheet is filed, you say that I'm juvenile. Give me the JJ. Yes. Yes. Yes.
The case has been charged sheeted, Your Honor.
Under which section?
Under section 329, 303, and 318, Your Honor.
Then you raise this issue before the court that you're juvenile.
Yes, Your Honor, but I only pray, Your Honor, to direct the GGB to.
Now it's no more before the JGB.
Yes, Your Honor, in the absence of birth certificate.
Now the matter is not before the JGB. How can I set the clock back? You go before the magistrate. And this magistrate has not decided that you are juvenile. You are not juvenile. It only says that it appears only for the purpose of custody. That it appears, yes, only for the purpose of custody. Magistrate does not say so that you are a juvenile or you are not a juvenile.
And before they send him to, before they send him to the general court, Your Honor, they did not conduct the ossification test for determination of age, Your Honor.
No, all these things you can agitate before the magistrate, isn't it? The matter has been charge sheeted. Now, what will happen to the charge sheet if I interfere with this order?
First, they have to take a plea in the trial court.
Yes. Then straight away you can come by way of revision. No need to come for an appeal.
If they are rejected, they can come.
Yes.
The
You can file revision. Not under JJM. You want to pass some order, you don't press for it. You want to pass some order, we'll pass an order. See, it is not a case that where the board has decided that you are juvenile or you are not a juvenile. So had you come, this order is dated 25/9/2025. Now had you come, immediately we would have stayed everything. And then we'll say that we would have resorted to section 1994. They say that if he was initially considered to be juvenile and subsequently if any evidence has come to show that he's not juvenile, you have got the right to be heard. Before you are declared to be adult, at least they should hear him. They should hear you. But now the investigation has concluded into a charge sheet. So you go to that court and argue before that court. And if the court is convinced, and then that court also can exercise its power under Section 94 and determine it. Court can order for a ossification test. So you want us to pass order or you'll press for it. All right. Heard under counsel Srimati So for the appellant. Yeah. Heard under prosecutor. This appeal, eh? There was a delay of 32 days in preparing the instant appeal. This court, by the order dated 27/11/2025, passed in Miss Case number. Passed in Miss Case number 13 of 2025, arising out of Criminal Appeal number 1 of 2025. Was pleased to condone the delay. That upon hearing the condone the delay, full stop. The petitioner / appellant has preferred the instant appeal, being agreed by order dated 25/9/2025, passed by the JJB Board Joy in connection with Raliang PS case number 26/09/2025 under section 329/3/3/316/4 BNSS. The copy of the impugn order is appended along with the memo of appeal at page 8, Annexure 2. Upon hearing the rival counsel and on carefully examining the impugn order, it emerges that the CCL was apprehended on 6/9/2025, 16/9. They was apprehended and produced before the JJB board on 16/9/2025. The CCL was remanded to the observation home pending inquiry / investigation. The CCL, after his apprehension, was produced before the board inasmuch as his age was reflected as 17 years. However, there was no documentary evidence to support his age. During further investigation, the electoral registration officer, during further investigation, it was found that the CCL was 19 years old on the date of alleged commission of the offence. The IO found the IO discovered the EPIC card and verified it from the electoral registration officer 4 hyphen Mokia Assembly constituency. The EPIC of the CCL was supported with a Baptist certificate the IO produced the EPIC card of the CCL after verification before the JJB board July with a prayer for remanding the accused. No, for the purpose of for the purpose of considering the accused, considering the CCL as a minor, as an adult, the prayer was considered by the JJB board by the impugn order. Consequently, it was ordered by the board that the CCL should be removed from the observation home. The petitioners agree by the impugn order, whereby the board had ordered for removing the CCL from observation home and holding the CCL as an adult. Full stop. Learned counsel for the petitioner submits that the board had held that the CCL is an adult without holding an inquiry and an opportunity of hearing with the CCL. Then the council further submitted that at the initial stage of investigation, the CCL was shown as 17 years old. Subsequently, the IO made a prayer for considering the CCL as an adult, as he was aged about 19 years. On the date of the commission of the offence. Full stop. The counsel for the petitioner submits that the impugned order is not sustainable and prays for the interference of this court. Learned prosecutor, next paragraph, supported the impugned order by submitting that there is no infirmity in the impugned order which calls for the interference of this court in exercise of appellate jurisdiction. This court has failed to comprehend. Next paragraph. As to how the petitioners agree by the impugned order. On carefully gleaning the impugned order, this court finds that when the CCL was initially apprehended and produced before the board, there was no documentary evidence to show that he was 17 years of age. Subsequently, during the course of investigation, EPIC card of the CCL was recovered, where his age was shown 19 years. The appellant before this court has failed to produce any documents to show that the CCL was 17 years. On contrary, the investigating agency has collected documentary evidence with regard to the age of the victim, age of the CCL. Full stop. The learned board, the board in paragraph 4 of the impugned order has specifically held that it appears that the CCL was adult at the time of the commission of the offence. Based on the material placed by the investigating officer before the board. Full stop. The board has not conclusively determined the juvenility of the CCL. It was only for the purpose of removing the CCL from the observation home. This court finds no infirmity in the impugn order, which calls for the interference of this court. This court has also been informed that the investigation has concluded in a charge sheet and the matter is pending for trial. And the matter is pending before the trial court. It will not be out of place to mention that when any question arises with regard to the juvenility of the accused, juvenility of the CCL, it has to be decided by following the procedure prescribed under Section 94. This court and least this court can do is that the petitioner slash the appellant slash CCL shall be at liberty to agitate the question of juvenility before the trial court, and any observation made by the board in the impugn order shall not come in the way of the CCL slash of the appellant slash CCL to agitate the question of juvenility before the trial court. With the above liberty given to the applicant, to the appellant slash CCL, this appeal stands disposed of. You agitate the matter before the court. That will be the appropriate court. Then you come here. If they don't consider, then you can come under revision. Yes. Yes. Next. Yes. What is Jolin Sunga?
Yes,
Yes. What is this?
now the parties appear.
Where? What is the amount?
This is the amount is 10 lakh.
Who is she?
Wife of
Where is the notice?
yes, wife of the deceased donor.
Wife of the deceased.
Yes,
And who is the other person?
and
What is the evidence that the husband wife?
this is a as per paragraph 3 or no, this marriage certificate. Paragraph 3 of
Where are the originals?
the original. And this another person is the only brother of the deceased person.
Do you have any children?
Only one, Your Honor, but she is the college student in the St. Mary's. As of now, she's having her exam. So that is why this could not.
Her NOC?
Yeah.
Her NOC is here.
Yes, Your Honor.
Where is the NOC by the daughter?
This is
Okay. What's the name of the daughter?
Miss Nikmen Sutrayon. Nikmen Sutrayon. Class Lilayo.
This is an application. This is an application. Give me the origin. This is an application under section 372 of the Indian. We just give the short forms. This is an application under section 372 of the Indian Succession Act 1925. Filed by the petitioner Srimati Jolin Sutunga, inter alia, praying for grant of succession certificate with regard to the debt and sureties left behind by her deceased husband. On first motion, this court was pleased to issue general notice calling upon interested person to file objection, if any. The notice is returned. No objection has come forth. Learned counsel for the petitioner, Sri So is present along with the petitioner. Learned counsel for the petitioner. On reading the application filed by the petitioner, it emerges that the petitioner belongs to Panar Scheduled Tribe community and she is a resident of YGL, West Jaintia Hill. Copy of the EPIC card is produced and marked as Exhibit 1 to substantiate that she resides within the jurisdiction of this court. The petitioner is the wife of, what's the husband's name? Wife of late Abraham Phawa. The marriage was solemnized under the Special Marriage Act 1954. On 25/11/2011. Copy of marriage certificate is produced and marked as Exhibit 2. The petitioner, out of the wedlock, sired a daughter, Srimati Nikmen Stunga, who is aged about 21 years now. The husband of the petitioner during his lifetime was working in the office of District Animal Husbandry and Veterinary, West Jaintia Hill, Joy. As what? As a chokidar.
Takidar.
How he died?
Due to his illness.
Copy of the identity card of service identity card is produced and marked as Annexure 4. The husband of the petitioner, Abraham Phawa, died on 2020 after prolonged illness. Died on 23rd June 2025 at Civil Hospital, Shillong. Copy of death certificate is produced and marked as Exhibit 5. Huh? Huh? 5. The husband of the petitioner, after his demise, left behind service benefits to the tune of rupees 10 lakhs 91,253. The same was communicated to the petitioner by letter dated 9 July 2025, which is appended along with the application as Annexure 5. The deceased husband of the petitioner left behind his wife bracket petitioner, daughter Miss Nikman Stunga, and a brother Yonis Pawa to succeed his death and sureties. The daughter and the brother of the deceased has given their no objection to the grant of succession certificate to the petitioner. Copy of no objection certificate which is appended along with the application is exhibited as Exhibit 6. The original 6. No, 1, 2, all. Check it order. There is sufficient material, there is sufficient evidence on record to show that the petitioner resides, not the petition applicant, that the applicant resides within the jurisdiction of this court. She was married to Abraham Poa, and her husband Abraham Poa was working in the veterinary department as a chokidar. The husband died intestate, leaving behind the petitioner as one of the heirs. The other legal heirs has given the no objection to the grant of succession certificate to the applicant. The applicant has also made a statement that the husband of the applicant died intestate, leaving behind no testamentary document. Further, no application is pending before any other competent court. This court also finds that there is no impediment under Section 370 of the Indian Succession Act to grant succession certificate to the applicant. The applicant is allowed to collect the debt and sureties left behind by her deceased husband, late Abraham Pawa, along with all interest and dividend which has accrued till date, subject to payment of admissible court fees the debt and securities left behind by the deceased husband of the applicant is described more specifically in the schedule herein below. This application stands allowed and disposed of uncontested. Yes, thanks.
Mansukh.
Your Honor, in this case, not file my written statement today, as
Have a good day, Honor.
that certificate was made available only yesterday.
I've just sent the appearance, Your Honor, this is the case.
Lombard, Bajaj.
No, but that's, Your Honor. I haven't received the copy of the case as well, Your Honor.
And you allow me, by next day, I'll be filing. Within 2 weeks' time also, I can file them.
We are for whom?
Insurance,
Insurance, but that's, Your Honor.
This is a debt case.
that case. It's a child, 3 years.
Who is appearing for the OP owner and driver?
None for today.
Notice, sir.
Yes, yes. Oh, last date they appeared in person, but they have not appointed a counselor.
Learned counsel for the claimant, so and so present. Learned counsel for the OP insurance. Bracket Bajaj Alliance General Insurance. Shri W. Dhar has entered appearance and filed his power. You're filing a power.
I'll file my power in the next day, Your Honor.
Has entered appearance. None appeared for OP owner and driver. Learned counsel for the claimant prays for time to file proper claim petition. Pray aloud. Fixed for steps by the claimant.
2 weeks.
Highly aware.
Objection.
Yes, please get the witnesses.
Yes.
How many witnesses we have today?
2. OVC.
She is a witness.
Yes, magistrate.
Which magistrate? Sangma.
Yes, GSD.
GSD Sangma.
Yes.
Morning, sir.
Morning.
Okay, madam, please take oath.
Okay, doctor, please take oath. Repeat after me.
Okay.
I swear that the evidence
I swear that the evidence
which I shall give before this court
which I shall give before this court
shall be the truth,
shall be the truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
So help me God.
So help me God.
Okay, doctor, in which year you completed MBBS?
2014.
I completed my MBBS in the year 2014. Do you have any specialized field?
I completed general surgery. 2017.
I'm specialized in surgery. I'm a specialist in surgery.
Surgery.
Yes.
So, in the year 2018, where were you working?
I was working in Dr. Norman Tunnel Hospital.
As what?
As what?
Under what capacity you were serving there? Under what capacity you were serving in normal tunnel hospital?
Under what capacity you're serving there?
As a general surgeon.
General surgeon.
You were serving in normal tunnel hospital. As a general surgeon. Yes. Please make it fast.
Well, in connection with this case, you have examined one patient who
Yes.
brought to you, and kindly tell us your examination.
Yes. So, patient was brought 8:30 p.m. to the hospital on the 28th October 2018.
Just maybe slow.
Wait,
The patient. What's the name of the patient?
What is the name of the patient?
Patient name is Paya Nangle.
Via Namling. Brought by whom?
Brought by his brother-in-law and his own brother.
Okay. Continue.
Yes. So when we received him, he gave history of assault.
Okay.
With the history of assault.
Assaulted by a known person to him.
Yes.
Yes. Go on. Go on.
Yes. He mentioned the name Mr. Mike. Hello.
And carry on.
And he sustained injury to the left side of the chest and the back of the neck. So the
Please make it fast.
After your examination, what is your opinion?
Yes, so he was examined and then we did suturing of the wound, which 12 into 5 into 3 centimeter cut injury on the left side of the chest, cutting through muscles and skin. And there is another cut injury on the back of the head, that is the scalp posteriorly. It's in the shape of a V, 1 centimeter each. The limb of the V is 1 centimeter each.
After your examination, what is your opinion? Did you give any opinion regarding the injury?
Yes, it is not grievous, not that's the nature of the injury.
Did you make
Simple in nature.
Did you make a report, injury report?
Yes, I
Yeah.
made a report. Yes.
Is this the injury report issued by you?
Yes, that's my signature.
You are being shown injury report dated 5. You are being shown. Being shown injury report dated 5 November 2018. The witness identified that this issued by him is exhibited as exhibit 4. Exhibit 4 by 1 is situation. Yes. That's all.
Doctor, when did this injury report you have prepared on the 5th of November 2018, right?
It was issued on the 5th of.
Okay. So when did you prepare this report then?
This report is just a copy of the findings that we have and the events that the patient come to hospital. So it was received, we have already prepared.
Okay, so
This report.
yes.
We have an MNC case.
Okay, so these findings where it was reduced into writing
I didn't get you.
on the 28th when this patient was brought in hospital, did you reduce into writing the injury sustained by the patient?
Yes, there is a written OT findings and all. Yes.
Okay.
Then we
Okay. First we'll record this statement first. On the 28th, 10, 2018, when the patient was brought in the hospital, who has did you by yourself reduce in writing the injury findings on the 28th?
Yes, it happened to be.
I have reduced in writing
This patient. Yes.
the injury sustained by injury detected on the patient. So this injury report, which was shown to you today, it was prepared on 5 November 2018, right?
No, it was issued to the person who received the report. Yes.
It was issued on the 5th of November. When was it prepared then?
Yes.
No, 1 second.
This the day when they come to collect the report, then we
1 minute, 1 minute.
Wait a minute.
This one. On 28/10/2018, when the patient was brought in the hospital.
I have refused in writing
The injuries of the patient.
No, it doesn't make any sense. Did he prepare the report? Be very specific on that.
Doctor, did you
After
prepare?
examining him, did he prepare the report on that particular date?
So on the 28, when this patient was brought in the hospital,
After examining him, did he prepare the report?
after examination of the patient, did you prepare the injury report? That particular day, when he is injured.
No, not necessarily.
You did not prepare a report on that day, right?
On that moment, no, we didn't take it.
The patient was brought to the hospital. After examining him, I did not prepare the report. My focus was on attending the patient. Yes.
As doctor, this injury report, when did you prepare then? The one which was shown to you today?
Yeah, exhibit 4.
In that, I don't recollect, but we do prepare a little later.
So you do not remember the date?
No.
I cannot recollect when I prepared exhibit 4. How I prepared later. Yes.
So this date which was reflected here, 5 November 2018, is not the date you have prepared this injury report, right?
What is the date in which the report
examined by the prosecutor, the defense counsel, this is discharged. Prosecution shall take steps to summon further witnesses. John? John?
Evidence, that's all. Yes. So you can look out. Okay.
You are coming from Assam, you are not coming from Assam. Oh, if you have got a case in CGM and you got a case in session court, which court do you appeal for? But none of the matters, we are just passing orders, none of the matters you are appealing. Item number 1, none appear. Item number 2, none appear. We have so many matters you don't appear.
Sorry,
What do you want?
Your Honor, I tried to contact them, but the phone was not working. I mean, I couldn't contact them.
You can't contact them, we contact them. What do you want now? What do you want? Where are those other accused persons? Where are those other accused persons? They have night,
I don't know, Your Honor. Actually, I am up here only for 4 of them.
but I can see two.
But I can see two. The father was not well today. So the other one, as they said that he's run away. I don't know, Your Honor. Yeah, yes, Your Honor. They as they have informed me, he's not with them.
You detain them.
Sorry.
You detain them. Unless they don't bring them. They are from SIP to get represented.
Yes, Your Honor. But
Yeah.
they are the two
They
that.
don't go back. They've been very kind to release them on bail.
Yes, Your Honor.
They were like languishing in jail for a considerable period of time. Release them on bail so that they appear. We are fixing long dates so that they don't have to come all the way from once in twice a month.
Yes, Your
And
Honor.
this is different appear. They're standing on a charge of murder.
Yes, Your Honor. I understand. I may apologize, Your Honor, for
No,
that.
you should not be apologetic for any. But then what do you want to do? What do you want exactly now? Yes, who's appearing for the prosecution?
I'm appearing here.
So what about the other accused person? See, we make it very clear that if we issue non-bailable warrant and
get them arrested, we are not going to release them on bail.
For the other accused, I am not aware, Your Honor, because I only present for this 4 only. So
Who are those 4?
the
You file Hajira?
yes, Your Honor.
You file?
Yes.
Where? Okay. You record later. Who are the accused persons you are representing?
I'm presenting the 4 of them.
Please give the name. Give the names to them. Later, so and so, both the accused persons give the name. They appear. What are the name of the accused persons?
Jintu and Utu. No. Subrato or Mithu. Jintu.
Appear along with defense counsel, Srimati so and so. The learned counsel further praised that the accused. Which are the 2 accused persons you want to be represented by you? Give the name. All right. How come you don't know the accused you are representing?
The name was quite similar, Your Honor. That they are
All right. You give the name. You give the name. You give the name. See, there are 2 accused persons. She wants to represent them. You give the name. Okay. And then the order will remain same for remaining other accused persons. Instead of bailable warrant, we issue non-bailable warrant for all, except 4. Please give the name of 4. We will not issue. For the remaining accused persons who are absent, as ordered above, non-bailable warrant shall be issued against them. And notice to the bailer. Yes. Yes. Yes, 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 yes. Please appear in time.
Yes, Your Honor.
If they are not there, still you can appear in time. No? Now again, we have
I
to pass the
apologize,
orders.
Your Honor,
Yes,
for
yes.
this.
Please appear in time. What about this matter number 7? This Chalam Langstang?
Your Honor, we approached them to appear. I'm taking case for the private, but they didn't want to take the case as private. So we already said to them we cannot take it anymore as citizen. So I don't know, Your Honor, they are going to take it a case. They're going to take another case or not.
Okay. Yes. This Samuel Singkon.
Yes, sir.
Yes. Yes.
Can I case the public? Like,
Yes. Yes. Yes.
Oh, kaya argument.
Yes.
Please.
How many witnesses are there? PW3, PW4,
Well.
PW5.
Yes.
They were sitting together and drinking.
No, Your Honor, the 5,
Yeah.
7, 8, and 9.
Yes.
Sitting along with us.
So please be very clear on one matter. Are you admitting that you have committed the crime? You want to argue the matter on merit? All right. If you have two-fold argument that on merit also the prosecution has failed to establish the case, then all right, we'll go into the merit. But if you are confining your argument, yes, I have committed the crime, but I was not mentally stable, then we need not to labor much. Okay? We will be focusing only on your mental status, whether you are mentally sound or not. So what is your defense?
Your Honor, one merit first.
Merit? Yes, okay. Yes. Be just brief. Yes.
Yes, sir.
Yes.
The instant case was the FIR was filed by Sri Shambor Latong,
Yes.
younger brother of the deceased,
Yes.
on 25/6/2015 before in charge Raliam Police Outpost. The FIR was received by Raliam OPGD number 03 dated
Receive the
25/6.
FIR.
Received the FIR
File when? Give me the notepad.
25/6/2015.
Yes, yes, yes. Please read the FIR.
Yes. How officer and sorry.
You don't have an English translated copy? Okay, read. Read the FIR. Be bit fast, because 2 o'clock we got some matter.
Subject
Come to the content of the FIR. Come to the content of the FIR. You have already stated that it was filed on 5/6/2015, isn't it? The FIR was filed on 5/6/2015, isn't it?
Yes.
So come to the content of the FIR.
55.
Yes. What is the allegation in the FIR? Please read. This case? We are hearing this matter for the first time?
No, Your Honor. Open my defense case on the last week.
Okay. Please. Yes. This session case number?
The allegation is that Sri Poi Prakhat
No,
Latong.
read the FIR. We want to know the verbatim of the FIR.
Okay. Kat kung katpeg subject balak kadeu hadeng is haban tantip yapi ba u Poi Prakhat Latong basong ba sa aga snong molber ula sha penyap hau somel songkon ubada kesnong molber hi uba ju khot sin ba songkon
Tabas Singkon.
apa upo sam jongka snong siar Haying Jong ka Marlini Sutanga Kabadai Trai Jong ka Patakiat Kade Kajing Sha Penyem Kalajiaha ka 23/6/2015 Hakapor Agui Baji Manmade
Yes, yes, okay. Yes, yes, yes. We don't want to do this. Rest is the character certificate for the person. Yes, please, yes. We got the FIR. File on 5/5, na? Yes, 5/5. No, sorry. 25th, 6, na? When was the FIR filed? Yes, madam, when was the FIR filed?
24th, Your Honor.
So where are you saying so?
So listed on 24th itself.
We're not concerned about his arrest. We are concerned about the file date of filing of the FIR. How come the first sentence, filing of the FIR, when was the FIR filed? 25th or 24th? You have the case diary na with you?
I submit already 25/6/15
Yes, please. Please proceed.
for the evidence of this PW3, PW4, 5, PW7, PW8, PW9.
Yes. All right. What is the evidence?
Allow me to read you. The prosecution examined 12 witnesses.
We are aware.
For the prosecution witness evidence is as
Are you ready for the case?
yes, sir.
Then tell us.
PW1 is just an inquest witness. PW2 is the headman of the village.
Yes.
PW3 Sweti Marlini Sutanga.
PW3 is the lady who was selling liquor patta, isn't it?
Yes.
So tell what is the evidence? She's eyewitness. She has seen the incident. What is it? What is the prosecution case on that? How does evidence of PW3 helps you?
PW3 it is established that the accused was present in the house on the night of
From
the
where are you
incident.
saying so?
Standard on the day of the incident, my three children were asleep at deceased, along with my five of his friends came to my house, and five others are asleep. Isoptron, Ping, Tanga, Monikai, Michael Manar, and Samuel Sungkon, the accused person, and they had drinks in my house. So from her statement, it is established that this accused is present.
Where he says the accused is present.
They had a drink.
Please read this. Read this evidence. Read the evidence of PW3.
On the day of the incident at 9 p.m., my three children were asleep.
You can use the microphone.
Were asleep, and the deceased, along with five others of his friend, came to my house. And the five others are Shri Esaptran, Shri Ping Sutman, Shri Monjalai, Shri Michael Manar, and Shri Samuel Sukhan, the accused person. And they had drinks in my house as I am selling liquor.
The six of them played music on mobile and were dancing. And at that time, as my youngest child was feeling sleepy, I took my baby to the room to make her sleep. And that time it was raining, and these six were waiting for the rain to stop and were dancing and drinking. Suddenly, I heard screaming, and I came out of my bedroom, and I saw the deceased Prakat Lathong lying outside my house in a pool of blood, while the five others, whose name I have mentioned above, were still inside my house. And after some time, the accused left my house. I and my husband asked the other who is still inside my house to inform the wife of the deceased, and one of them went to inform the wife of the deceased. He came only on the morning, and I also went to inform the headman in the morning. I do not know who has killed the deceased, as I do not see.
Yes. Yes. Then
And the cross, it is
cross,
correct that my
cross.
cross of
You cross
PW3.
PW3.
Yes.
But here say decline.
Your Honor, we will examine her.
Okay. Cross of PW3. Yes. Yes,
It
please.
is correct that my statement was taken and recorded by the police. It is correct that the accused Samuel Sungkun came to my shotgun residence at 7:30 p.m. It is true that after 10 minutes or so, five persons, namely Esoptron, Michael Manard, Ping Sutungai, Edman Yakai, and Poi Prakat Lathong, the deceased, came to my shop. My husband, Niborni Lamre, was also present. It is a fact that my husband was sleeping near the fire and Samuel Sungkun was sitting beside my husband. And it is a fact that the other five persons mentioned above were sitting in the other side of the room. It is a fact that the five persons mentioned above were drinking, playing music, and dancing. After they were dancing, later on hearing the scream, I came out and saw all the other five persons, including my husband and Samuel Sungkun, was still inside my shop, come resident. It is a fact that my husband was still inside the shop along with Samuel Sungkun at the time when I went to look at the deceased. I have knowledge that Samuel Sungkun was suffering from mental disorder. However, I have no knowledge whether he was admitted to Minhang prior to this case. It is a fact that I do not see.
Yes. Then PW4. Read PW4.
On the day of the incident, I was at home coming back from work, and when I reached home, I found the deceased along with
Who is
Shri.
PW4?
PW4 is the husband of PW3.
Yes, please read.
Along with Sri Esaptran, Sri Pingsutnga, Sri Manyalat Yakai, Sri Michael Manar, and Sri Samuel Singkon, the accused person, in my house. I had my food and I went to sleep near the fireplace, which was partitioned, and the other side of the partition, these people were sitting and drinking. I was fast asleep when I suddenly heard the shouting and fighting of these people, and by the time I woke up, I saw the deceased outside my house, lying dead in a pool of blood. While the five of them were sitting inside my house, and after some time, the accused person left the house, and I told those who are still in my house that one of them should go and inform the wife of the deceased, who came in the morning, and during the night time, I and my wife were with the dead body of the deceased and informed the headman on phone the next morning.
Yes.
And members of the village came to the PO and informed the police, who came and removed the dead body.
Okay.
I do not see who killed the
PW5.
W5 on
He also was there inside the house, isn't it?
Yes.
Those five people named together, they came. This PW5 also is one of them.
Yes.
Okay, please read.
On the night of the incident, I, along with the deceased, Michael Manard, Ping Stunga, and Monyakai went to the house of PW3. And reaching the house of PW3, we found accused Samuel Sinkon already in the house of PW3 with PW4, husband of PW3, and accused was drinking. We also joined in the drinking and dancing to the music in the mobile, and after some time, I, along with Ping Man Michael, became dead drunk. When I regained soberness, I saw the accused at that time stabbing the deceased, and I ran away from there as I was scared seeing this.
Yes. What is your cross-examination to this?
Because we were already in the house of PW3 when her husband PW4 came. That night it was heavily raining and it was quite dark and we could not see
You say 1 minute,
anyone.
1 minute. Where is this cross? This. Okay, I got it. Sorry. Yes. We were already.
And could not see anyone. I do not remember the time when we reached PW3 house. I was dead drunk for quite a long time. Outside it was dark, but inside the house there was light. I have no enmity with the accused person. Accused is from the same village where I stayed, and his house is quite a distance from my house. I saw the accused stabbing the deceased with a knife. Witness also gestured with his hand to show how the stabbing occurred. The accused stabbed the deceased using his right hand. Seeing this, I screamed and ran away from there. At the time, I felt that drunk. It was in the room where we were drinking, and that room is partitioned with a plank. I was examined by the police in this case. I have stated before the police that I saw the deceased going out for nature's call. The incident I saw happened in the veranda of the house and I was in the room we were drinking.
Yes. PW7. This one also, he was there inside the house?
Yes.
Yes, please read.
The incident was in sometime in the month of June, the date and year of which I cannot remember now. On that night, after finishing our work, I, along with my friends, Michael Manar, Edmund Yakai, Atron, and the deceased, went to have drinks in a place called Purjiang. When we reached the liquor shop,
You reading? PW?
PW7.
6.
6, no, it's not the day. He's the deceased brother. It's only informed.
PW 6. 7 years. Yes.
The incident was in sometime in the month of June, the date and year of which I cannot remember now. On that night, after finishing our work, I, along with my friends, Michael Manar, Edmund Yakai, Etron, and the deceased, went to have drinks in a place called Perjian. When we reached the liquor shop, we saw the accused was already there in the liquor shop. However, I and my friends sat in a separate room away from the accused and had drinks. That night it was raining heavily and we waited for the rain to stop, but it did not stop. And in the meanwhile, we all went to sleep in the shop. During the night, as we were all asleep, we could not hear any noise or commotion in the shop, but we just suddenly heard the deceased crying out for help, saying, "Rab Lok Nade Yap Am. Help me, friends, I am about to die." Hearing this cry, we woke up and rushed outside the shop room and saw the deceased lying on the ground asking for water. We asked the deceased what happened and who did this to you, and the deceased replied that accused Samuel did this to him. The deceased thereafter expired and we ran away from the place as we were scared.
Yes.
No, PW8. On the night of the incident, I, along with Michael Manar, Etron, along with the deceased, went to have drinks in a place called Kujian. This was in the month of June 2015. When we reached the liquor shop, we saw the accused was already there in the liquor shop. However, I and my friends sat in a separate room away from the accused and had drinks. That night it was raining heavily and we waited for the rain to stop. And meanwhile, we were also listening to music on our mobile, but the rain did not stop. And in the meanwhile, we all went to sleep in the shop. During the night, as we were all asleep, we could not hear any noise or commotion in the shop, but we just suddenly heard the deceased crying out for help, saying, "Rab Long Hade Yapon, help me, friends, I am about to die." Hearing this cry, we woke up and rushed outside the shop and saw the deceased lying on the ground. We wanted to give him water, but the deceased was no longer in a position to take the water, and seeing that the deceased had died, we ran away from there.
Yes.
And PW9. On the night of the incident, I, along with PW7, 8, Shri Itron, along with the deceased, went to have drinks in a place called Pujiang in the shop of.
Same.
Yes.
Yes. Yes. Now tell what is your case?
From the evidence of this PW5, PW5 said that When I regained soberness, I saw the accused at that time stabbing the deceased, and I ran away. So he saw the disease. He saw the accused stabbing the deceased. PW5 stated, and and in PW7, when PW7, when they inquired from the disease, the the disease answered that it was the accused who did this to him. PW8,
What is the evidence of the IO? Medical report, the post-mortem report, evidence of PW10 clearly shows that this was a case of homicide.
yes,
Look at the finding of the medical report. Look at the finding of the doctor who conducted post-mortem. Incised wound on the back, left side.
left side,
Incised wound on the left forearm. Stab wound on the back of the lower part of the left thigh. Injury of the left muscle bicep femurs. Injury of the popliteal vein. Incised wound on the right lower chest below nipple. There is a fracture of the right seventh rib. Yes, tell me one thing. Yes, look at the kind of injury.
multiple injuries. Yes.
Huh? Can an injury be inflicted by one person? So much injuries. It may be a case that all the persons they might have assaulted him and put the blame on him. Put the blame on the accused. Look at the nature of injury. He died on the spot. Look at the nature of injuries. All of them, they were present there. Yes. Yes. The IO. What is the evidence of the IO?
PW11.
We want to know we are very curious to know how did the IO file a charge sheet against one of the accused persons? What is his evidence?
On 24/6/2015 at 7 a.m., I received a telephonic call from Shri Tengong, Senat Headman of Sia Village.
Is he a witness in this case?
The headman?
Yes. No?
No.
Okay. All right.
Informing me that Shri Porkat Lathong of Molabaya village has been murdered at Sia village. On receiving of the information, myself along with available ready party rushed to Sia village by a departmental vehicle. We arrived at Sia village at around 9:45 a.m. On arriving, the local headman led us to the house compound of Srimati Marleni Stunga, wife of Shri Nambami Lamari at Sia village. Thorough search was conducted at the PO, but no any murder weapon could be recovered. I hold inquest over the dead body of the victim on being identified by Srimati Darihun Marang of Molabaya village, and she disclosed the name of the deceased victim as Porkat Lathong. After conducting the inquest, I examined Shri Bunboksna, headman of Sia village, Shri Bhalang Lamare, secretary, Srimati Marleni Stunga, Shri Nambarni Lamare, Shri Esaptran, Shri Michael Menard, Shri Ping Stunga, and Shri Edmund Desai.
Out of these people, how many they have appeared before this court as a witness? The headman never came before this court as a witness because he was the first person to inform about the incident to the police.
Is PW1.
Headman.
Yes. The requested as
Okay, yes, yes.
The secretary on a Bhalang Namari of
During this period.
Yes.
Okay. Okay.
And after examining this witness, as per the statement of the witness on 23rd 6 2015 at around 7:30 p.m., Sri Samwa Sankan of Molabe village came to the shop of Malini Stuma as she ran a local liquor shop at Sia village. After about 10 minutes, five persons, namely Sri Isatran, Sri Pingstunga, Sri Michael Benar, Sri Edman Yakai, and the deceased victim, Wabrakat Nathong, came to the shop of Malini Stuna and she served them local liquor. And during that time, Sri Nambami Lamri, the husband of Malini Stuna, was also present. During that time, Sri Samwa Sungkon was sitting beside Sri Nambami Lamri and the five others were sitting in opposite side inside the shop. They were drinking alcohol and listening to music on their mobile phone. Then at around 8:40 p.m., the deceased victim, Paul Khan, went outside the shop for nature's call and Sri Samwa Singkan followed the victim from behind and suddenly all those present in the shop heard a scream and on hearing the scream of Babakat Lathong, Esaptran, Michael Manar and Edmund Yakai came out of the shop and saw the deceased Babakat Lathong lying on the floor with injuries and Sri Esaptran helped the deceased victim who asked for water and also the victim told Esaptran that Sri Samwa Sungkan had assaulted him. All those who are present there were terrified of the incident and afraid, so they ran away from the PO to the village and on the way, Sri Esaptran met one boy who was the relative of the deceased victim's wife and he directed the boy to inform Srimati Darihun Maram that her husband is not well. Sri Nambami Lamre and Srimati Marleni Sutuna, who were owner of the liquor shop, were sleeping in their own room and when they woke up in the next morning of 24/6/2015 at around 6 a.m. and saw that the deceased was lying outside her house in a pool of blood. Immediately, Srimati Marleni Sutuna went to the house of local headman and informed him about the matter, who in turn informed the police. Later, the headman of Sia village, the accused person, was apprehended by the BDP member and kept at the school in the village. On learning about the information, we proceeded to the school at Sia village and took the accused person in a custody and moved to Ruliang outpost along with the corpse of the deceased. The dead body was sent to civil hospital Chawai for postmortem. Written FIR was lodged by Sri Shanbor Lithong on 25/6/2015
Yes.
and the same was forwarded.
Yes, yes. So tell me. Now we understand. Yes, what is it?
From the evidence of this Bill 9, Bill 8, it is clear that the accused has committed the offense of murder
Why should we believe them?
because they say so in the evidence.
Huh?
They have
Why did
stated
they run away? Why were they scared and they ran away?
they ran away because they were scared. They said,
Why were they scared if they have not done anything? And the evidence of the IO, how does it help the prosecution case? The IO was never present there. He's narrating about the incident, what exactly happened. How did he know that he went for the nature's call and he followed him and stabbed him? How did he know? It has to be somebody might have stated before him, isn't it? Where is the witness who stated that he went for nature's call and the accused followed him and stabbed him? Which witness stated that? Look at the evidence of this PW7 and PW8. Verbatim, exactly same. But look at the nature of injury suffered by the deceased. Is it possible for one person to cause such injury? Any weapon seized?
no weapon seized in this case.
Then all incisive wound by a sharp weapon. We will believe a statement of a witness against whom there is suspicion that he may also be involved in the case. Should you believe the statement of a witness who is tainted of being suspicious? Yes. Yes. Yes, madam. What is the prosecution like? What will be the prosecution? What do you have to say on merit?
Your Honor, on the 23rd June of 2015, I went to the house of Srimati Marlene, that is PW3, to have a drink alone. And I reached there at around 7:30 p.m. So after 10 minutes or so, these four PWs along with the deceased came and sitting on the other side of the room that is covered, that is parted with a wooden plank. And these four PWs have plotted this case against me, taking advantage of my well-documented mental illness. So while I'm saying this, that I do not commit it, I'll point out the evidence which I do not do it, why I did not do it. So PW3, that is the owner of the house, she's the most important witness in this case. Her testimony contains three crucial admissions. Firstly,
Contains what?
three crucial admissions.
What is it?
Number one, accused was inside with PW4 at the time of the incident.
PW4 is the husband.
Yes, husband. She deposed that the accused was sitting beside her husband, PW4, near the fire when the deceased went outside. At the time she heard the scream, the accused was still inside. Number two, knowledge of accused mental illness. She admitted that she had knowledge that the accused was suffering from mental illness, though she had no personal knowledge whether he was admitted to MIMHANS. This corroborate their medical evidence and suspicion on the other PWs. She clearly admitted that she did not know who killed the deceased and went further to state that the other four persons who came along with the deceased may have concealed their involvement from the crime. And Your Honor, the PW5 who claimed that he saw the accused person stabbing the deceased, however, admitted that he was dead drunk and had lost consciousness. And he also admitted that it was raining heavily and dark with poor visibility. And before the police, he stated that the deceased had gone out for nature's call, contradicting his later testimony.
What is it?
He stated that the deceased had gone out for nature's call, contradicting his later testimony. His version that he saw the stabbing while he was inside a partitioned room.
Who says this?
PW5.
PW5 says what? When he was inside the room.
Yes, he was inside the room. And he saw the stabbing while he was inside the partition room.
Saw the accused at the time of stabbing.
The question here is, how can he see outside when there is a partition?
See, in cases of this nature, when all they were sitting together, drinking and listening and merrymaking, there has to be some motive. These kind of cases, motive becomes very important. Why will this person stab him? Why? Yes, you mean to say that it was not possible for him to see because he was sitting in a partition room.
And also, if he saw that, why he did not confront the accused person at that time, though he saw the accused stabbing the deceased. And he ran away.
And I read some evidence that the IO saying that he went out for the nature's call and he followed.
Yes.
He followed. And the accused followed him.
And the accused followed the victim from behind.
Yes. That means they went outside the house.
Outside, not the house.
Where was the body found?
The body outside the house, not in the veranda.
But where is the place of occurrence?
Outside.
Outside.
Whereas PW3 stated that the accused at the time of the incident, he was inside with her husband, sitting near the fireplace.
PW3.
PW3 is on her cross.
That's all?
Yes.
That's all? Anything on insanity?
Your Honor, I place one judgment with regard to the
Was case.
Goa cases.
But no, but where is the question of he being insane? Insane person will not go to somebody's house, drink, listen music in mobile. A person may be having some history of mental unsoundness, but in order to get the benefit of Section 84, at that point of time when the crime was committed, it should be shown that he was not mentally sound and he did not have the knowledge of what he was doing.
Your Honor,
He may have, please, I've already passed some judgments on that, making a distinction on mental insanity and legal insanity. We are not concerned about the mental insanity. We are concerned with legal insanity. Means at the point when the crime was committed, he was not mentally sound. But looking at his conduct,
my argument is only on merit.
yes, that's all.
Yes, it's only that the
Learned
all
counsel.
the PW is taken advantage of
Sorry?
mental documented in this.
Give me learned counsel, learned counsel, learned counsel, Srimati. Learned additional prosecutor, Sri so-and-so, learned counsel, Srimati so-and-so. This matter has come up for final argument. Stop. This court is of the view that facts of the case needs to be briefly recapitulated for the purpose of evaluating the evidence and determining the charge. Stop. The instant criminal proceeding was set in motion. The informant is PW 6. The informant is PW 6.
Yes.
The instant criminal proceeding was set in motion by Sanbor Lathong by filing an FIR dated 25/6/2015 before the officer in charge, Raliang Outpost, West Jaintia Hill. The FIR was forwarded. The FIR was received by GD number 3, dated 25/6/2025, and it was forwarded to Jawai Police Station for registration. Full stop. Accordingly, it was registered as Jawai PS case number 128/06/2015 under section 302 IPC. The FIR was written in a vernacular language for better comprehending the allegation. The translated copy of the FIR is reproduced. The investigation of the incident case was entrusted to L. Singpan, SI L. Singpan. The IO, during the course of investigation, conducted inquest over the body of deceased. Thereafter, the body was sent for post-mortem examination. statement of witnesses was recorded under section 161 CRPC. Sketch map of the PO was prepared. The IO concluded the investigation by filing CS number 91/2015 dated 24/8/2015 under section 302 IPC. This is a committal order. The charge sheet was laid before the learned CGM. The learned CGM, after complying with section 207, committed the case to this court by committal order dated so and so. Charge was framed against the accused person on 8/6/2016 under section 302 IPC. The accused pleaded not guilty, demanded trial. The prosecution during the course of trial examined 12 witnesses and exhibited three documents. The details of the PWs and exhibits is appended in the appendix of this judgment. After the examination of the prosecution witnesses, the accused was examined under section 313 of CRPC, and he was given an opportunity to bring defense witnesses. The accused declined to bring any defense witnesses. As such, the matter proceeded. The matter has come up for final argument. That on gleaning through the records, it emerges that the accused, who is in custody, has a history of mental unsoundness. He had been admitted to Mimans for medical treatment. Nevertheless, there are medical evidence to show that the accused is fit to face trial. Though the defense has not contended on the ground of insanity, has not contended the ground of insanity, this court shall bear in mind the health condition of the accused while evaluating the evidence. Stop. Prosecution's argument. Learned prosecutor has drawn attention of this court to the prosecution evidence, more specifically the evidence of PW2, more specifically the evidence of PW3, PW4, PW5, PW7, and PW8. The prosecutor submits that the accused was in the company of PW 4, 5, 6, and 7. At the residence of PW 3 on the fateful day. They were drinking and listening music. The house of PW 3 is used for selling local liquor. The accused, after consuming alcohol, stayed back in the house of PW 3 as it was raining very heavily, waiting for the rain to stop. PW 3, 4, 5, 6. PW 3, 4, 5, 7, 8. While waiting for the rain to stop, went to sleep. Suddenly, they heard a cry and found that the deceased was stabbed by accused to death. The prosecutor submits that PW 5 saw the accused stabbing the deceased. PW 5 has specifically stated in his evidence that he has witnessed, that he is an eyewitness to the stabbing of the deceased by the accused. The evidence of PW 7 clearly establishes that the accused stabbed the deceased, and the deceased, before dying, made an oral declaration that he was stabbed by the accused. Lawyer prosecutor submits that the evidence of PW 3, 4, 5, 7, 8 is consistent, and it corroborates with the evidence of the doctor PW 10, who conducted the post-mortem examination over the body of the deceased. The post-mortem report, which has been exhibited as Exhibit 3, clearly reveals that the cause of death was a hemorrhage, and the injury found on the body of the deceased was fatal. As such, it is a case of culpable homicide amounting to murder. The IO of the instant case, PW 11, has stated in his evidence that it was the accused who had caused the death of the deceased. Full stop. The prosecution submits that the nature of injury found in the body of the deceased in the postmortem report Exhibit 3, clearly demonstrates that the accused had inflicted injury with the knowledge and intention to cause death. As, as such, it is a clear case of a culpable homicide amounting to murder, punishable under Section 302 IPC. The accused, the prosecutor prays for conviction of the accused under Section 302 IPC. Next paragraph. Defense argument. Learned defense counsel submits that the evidence of PW3 is very vital. As per the prosecution projection of the case, the incident took place in the residence of PW3. PW4 is the husband of PW3. PW3 in her evidence has disclosed that she heard the noise in her house when the accused persons along with his friends were there. She had also served alcohol to the accused person. After hearing the noise, she went out of the house and saw the deceased in a pool of blood. However, she has stated in her examination in chief that she did not know who killed the deceased. You underline that. PW4 is the husband of the PW3, stated in his evidence that the accused was with him when the incident took place. The defense submits that when the incident took place outside the house. How can a person commit a crime outside the house when he was present along with PW4? This creates a very serious doubt. Countering the argument of the prosecution that PW5 saw the accused stabbing the deceased, the defense submits that the PW5 was drunk, not in his sense, and he was in a partition room. It was not possible for PW5 to see to be a witness to the incident. The defense further submits that PW3, PW4, PW5, and PW7. PW3, PW4, PW5, PW7, PW8 were all present in the house. Drinking, were all present in the house of, were all, no, don't write PW3, PW4, were all present in the house of PW3. They were having a gala time while waiting for the rain to stop. PW 5, 7, and 8 has stated in his evidence, in their evidence, they went while waiting for the rain to stop. They went to sleep, and it was only after hearing the incident, after hearing a cry, they got up, they woke up, only to see the deceased lying in a pool of blood, dead. Which is hard to believe. The defense submitted that the accused has been made a scapegoat by the witnesses, more specifically PW 4, 5, 4, 5, 7, 8. As the accused has a history of mental unsoundness, he was found to be a soft target to be implicated. The defense submits that the prosecution evidence which is unfolded during trial is not worthy to be trusted, and if at all any evidence has emerged, has any evidence, and not if at all, and the evidence which has a role during trial only give rise to suspicion, and this suspicion is not only towards the accused but also against the accused person, but also against the other witnesses. The defense concluded the argument by submitting that suspicion can be no ground for convicting an accused. The prosecution evidence has to pass the test of beyond reasonable doubt to succeed. The defense prays for acquittal of the accused. That upon hearing the rival counsel and on examination of the evidence on record, following points are formulated for determination. Number one, whether the accused, along with PW4, no, PW5, PW7, PW8, went to the house of PW3 on 26/3 on went to the house of PW3 on the night of 23/6/2015, and there they consumed liquor. Number two, whether the accused caused the stab injury. What's the name of the deceased? Prakalatong. And caused his death. Whether the accused caused the stab injury to the deceased Prakhat Lathong on 26 2015 in the house outside the house of PW3 and caused his death. Stop. Next. Decision and the reason thereof. Stop. Point number one. From the evidence of PW3, it is apparent that on the day of the incident, PW3 was at her residence along with her 3 children and the deceased. 5 persons came to her house, namely Shri Yobon, what is that? Isop Tron. Isop Tron, Ping Sunga, Mon Yelai, Michael Manar, and the accused. She had served liquor to the accused and the others. The accused person along with their friends, along with his friend, they were dancing and listening to music in the house of PW3. This evidence has not been shaken. On contrary, in cross-examination, it has been confirmed. It further gets fortified with the evidence of PW4, husband of PW3. It is also consistent with the evidence of PW5 and PW7 and 8. The defense has failed to elicit any evidence which will make the evidence of PW3, 4, 5, 7, 8 unbelievable. Koa, the accused, went to the house of PW3 on 26/6/2015. This court need not to labor much to drive home the prosecution case that the accused went to the house of PW3 along with his company on the fateful day. This court says so inasmuch as the evidence of the prosecution witnesses on this point remains unshaken. Further, it has been fortified in the cross-examination. The prosecution has established that the accused went to the house of the accused on such and such date. Next point. This is the crux of the prosecution case. At this point, this is the crux of the prosecution case. This will this point for determination. No, this point for determination is the crux of the prosecution case, comma. It will determine the culpability of the accused. Full stop. Coming to the prosecution evidence, this court finds that who is the informant in this case?
Brother of the deceased.
Huh?
Brother of the deceased.
PW?
W6.
Younger brother.
Younger brother or the daughter?
PW6.
Brother.
The deceased is my elder brother.
PW6 is the informant in the instant case. The evidence of PW6 reveals that he was informed about the incident over the mobile phone by the wife of the deceased. After receiving the information, he went to the house of the deceased along with the police and he filed the FIR. The FIR, the facts alleged in the FIR has been narrated above. The informant is silent in the FIR that he received the information about the death of his brother. He or she? No, the informant.
His brother.
Yeah. The information, what's the last sentence?
Information is silent in the FIR that he received the information about the death of his brother.
Over the phone. The informant is silent with regard to the involvement of the accused. The informant PW6 is silent about the involvement of the accused. The informant in his evidence, the informant PW6 in his evidence is silent with regard to the involvement of the accused in causing death of his brother. However, in the affair, the informant PW6 had named the accused. This is a serious lapse. No doubt. FIR is not an encyclopedia of the case. Nevertheless, a person who had triggered the criminal proceeding naming the accused in the FIR, Exhibit 1, failed to name the accused before this court. In other words, the fact alleged in the FIR with regard to the accused causing death has not been established. Coming to the evidence of PW3, PW3, after confirming that PW 4, 5, 7, 8 were present in the house on the fateful day, stated that she did not know who killed the deceased. All the accused persons, all the witness, the witness PW 4, 5, 7, 8 were present in the house of PW 3. They were drunk and having fun. They have stated in the evidence that they were fast asleep, waiting for the rain to stop. If they were fast asleep, it was impossible for them to witness the incident. PW5, PW3 was present there, stated that she did not know who committed the crime, but others who were present disclosed the involvement of the accused in the commission of the crime. This raises a serious doubt, and this court needs to be very careful while while evaluating the evidence. On perusal of the post-mortem report, Exhibit 3, this court finds the nature of injuries found on the body was multiple and it gives an impression to this court that many more persons were involved in causing injury. The accused alone cannot be the author of the injury found in the post-mortem report Exhibit 3. The injury found on the body of the deceased are hereunder. Will give the findings. The above injury cannot be inflicted by one person alone. And the weapon used for causing injury was never seized or to be found. After the incident, PW 3578 fled away, citing reasons of fear. However, the same breath, PW7 stated that on seeing the deceased lying injured, he tried to offer water, but the deceased was not in a position to consume water. The deceased disclosed to PW7 that the accused had caused injury to him and he's going to die. The above statement may be construed as an oral dying declaration. However, in order to act on oral dying declaration, it should be above all suspicion and doubts. Here, the suspicion surrounds the evidence of PW3, 4, and 7. PW3, 4, 7, and 8. One possible view is that the accused, along with PW4, PW5, 6, and 7, were all involved with the incident case. And this view comes from the post-mortem report, which indicates multiple injury on the body of the deceased. It is always said that when an evidence comes through human process, there's bound to be some discrepancies. But looking at the evidence of PW 9, PW 8, PW 7, this court finds that all the witnesses have spoken replica of each other, which raises serious doubt. And it adumbrates, perhaps they might have been influenced or tutored to speak in same voice and to be on same page. The IO has narrated about the incident in his evidence. The IO was never present when the incident took place. If at all, he's narrating about the facts of the case. The basis has to be on the statement of the witnesses he recorded. None of the witnesses has stated that they saw the deceased going out of the house and the IO and the accused followed him. The accused followed and stabbed the deceased. It appears that the IO is building up his own castle, which has no foundation. Full stop. This court finds the evidence of PW 3. This court finds the evidence of PW 5, 7, 8, and 9 is surrounded with suspicion. When this court says suspicion, it's not only suspicious, but the suspicion points towards them, indicating that perhaps they might have deposed to protect themselves, depose against the accused to protect themselves. This court is not inclined to rely on a suspicious evidence for the purpose of convicting the accused under section 302. For the reasons discussed above, this court finds the prosecution has failed to establish the charge under section 302. The accused Samuel Sincon is acquitted of the charge under section 302 due to lack of evidence. The accused who is in custody shall be set at liberty forthwith unless wanted in some other case. Case stands disposed of. The IO is directed to destroy material exhibit, if any, after the expiry of the statutory period of appeal. The bail bond of the accused shall remain in force till the expiry of the statutory period of appeal. Thereafter, without any further order, the bail bond shall stand discharged. Okay. Yes. Yes. That's all. Yes. What else we have? This one we passed an order. He should be released immediately. His family members are there.
Last time I asked him, only he came over there. His wife also expired.
Uh-huh.
So last occasion, his sister had come here. Do not remember.
Let him. Okay. Yes. That's all. Anything else?
You
No. Not today. I think we are a bit tired today. It's 3 now. Beyond court hours. Yes. Anything else?
Your Honor,
Yes.
I have an application for anticipatory bail which has been registered.
Anticipatory bail. How many?
3 persons, Your Honor.
This that case with correction of Lapangap, where the Assam police has sought custody. This is the same case.
What is the section?
103 murder case.
Murder case. Anticipatory bail. Why?
Your Honor, the applicants here are the headman, the assistant headman, and the secretary of the village.
Yes.
Your Honor, on the 9th of October, while the village were going to the paddy fields to harvest the paddy, despite the presence of Assam and Meghalaya police, the other sides, the Karbi people from the other side started shooting slingshots and disturbing the paddy cultivation. What happened after that was, despite the presence of the 2 police force, they came into a clash. It was a mob clash. And unfortunately, in that incident, when Mr. O. Timung was injured and later succumbed to his injuries. Now, Your Honor, on the basis of that incident, on the next day, Nottingham Police, first the FIR was filed at Raitsama Police Station.
Who filed the FIR?
This was filed by UBSIP1, Saitsama OP, West Jaintia Hills. And this is a police FIR, Your Honor.
Where is the copy of the FIR?
Copy is here, Your Honor.
Page?
Your Honor, just Annexure 1.
Yes.
Later, this was registered as Nottingham Police Station case.
Let's read the FIR first.
Yes, sir.
Let's read the FIR.
Okay. To the officer in charge, Saitsama Police Outpost, West Jaintia Hills District. Subject FIR regarding breach of peace leading to 1 death and several injured. Sir, with subject cited above, it is humbly submitted that self has been deployed for law and order duty regarding harvesting of crop at Lapangat village under West Jaintia Hills District. Further, it is to be noted that today at around 11 a.m., harvesting commenced in the paddy field of Lapangat village. Despite presence of Assam and Meghalaya police, a mob of people from Karbi side attacked the farmers' workers who were harvesting the paddy. Initially, slingshot and catapults were used, but later physical confrontation ensued with stick, dows, and other dangerous weapons between the villages of Tapat and Lapangat village. Seeing the sensitivity of the situation, Meghalaya police team showed with utmost restraint, yet few injuries were reported. Later on, I received source information that one person, Sri Oniwal Timung, son of Sarpang Timung, resident of Tapat village, was found unconscious at Charngan under Lapangat village. Later, he succumbed to his injuries, as informed telephonically by Assam police. During the course of law and order deployment, several police personnel from Meghalaya side got injured in discharge of their official duty. Reasonable force was used to control the mob, which was declared unlawful.
Okay, but you are not named in the FIR. What is the apprehension of arrest?
The apprehension of arrest is this, Your Honor, that in fact they have received information that the police are looking for them.
But you are not named in the FIR.
Your Honor, even despite the fact that they have not been named, there is credible information that the police are looking for them.
Yeah, but why should they look for you? You are not named in the FIR. There was a group clash between two rival groups in the bordering area.
No, this is the whole crux of the matter, Your Honor, because nobody is named. So they are, the police, in fact, are looking for everybody. So since the headman, the assistant headman, and the secretary, in fact, they were present on that day. So now they are looking to bring them in for questioning, which ultimately, Your Honor, we do not know what will happen.
Okay.
Because this is a clash between two groups from separate states. Now, Your Honor, in relation to the charge, Your Honor, I would like to point out that despite the fact that they have framed murder and other charges, but it is very strange that they also have framed charges under, that they have also included charges under Section 331, Clause 5, and Section 332 of the BNS, which relates to lurking house trespass. So, based on this, it seems that even the police are not really sure about what they are going, and ultimately
You call for the case diary.
Yeah.
Call for the case diary. These are all same case.
Same cases. Only in the case of the headman, Your Honor, he is suffering from acute metabolic syndrome.
Okay.
We have provided the medical report, the prescription.
Others are here.
Yeah.
Where are they?
No, all three of them are here.
Where are they?
They are downstairs, Your Honor.
I call them.
Go, call them.
Yes. How many are there? Three.
Three, Your Honor.
What is this? One. How many? This one. One. All right. Learned, this is a bill application number 28, 2025. But you just give the names, petitioners also. Bill application number, who is that? 25, 28, 29, 30. Yeah. This three bill application is taken up at this stage by a common order, as it arises out of a common case. A bill application is moved by learned counsel Sri E. Stuart.
Urban case in Sudan.
The application is supported by an affidavit. Supported by an affidavit and moved by that on top. So the application, bill application, this will be pre-LS bill application. Pre-LS bill application is supported by an affidavit and moved by learned counsel Sri so and so. Her learned counsel for the petitioners S. Her learned prosecutor Sri so and so. Learned counsel for the petitioner submits that the petitioners in the above three bail applications are the local head of which village?
Lapangap village.
Of Lapanga village. An FIR was filed on 9/10/2025 before the Saitsama police station. And in the FIR, it has been alleged that there was a clash between the residents of Meghalaya and Assam in the bordering area of Mukro,
No. Lapangap and Tapat.
The bordering area of
Lapangap.
Lapangap and
Tapat is the Karbi village.
Tapat village. And in the clash, one person lost his life. The petitioners has not been named in the FIR. However, being the local head, they are apprehending that they may be arrested. The FIR has been registered as, what is this? Nartiang. Nartiang PS case number, you just guess number, huh?
34.
Yeah.
10.
All the sections also. And all the sections are non-bailable. In event of the arrest, it will put the petitioners into extreme hardship and embarrassment, inasmuch as the petitioners have no role, and inasmuch as the petitioners have no involvement, in the instant case. Put stop. Next para. The learned counsel prays for intervention of this court at this stage by protecting the petitioners from being arrested. Put stop. Next one. Learned prosecutor submits that case diary will be necessary for the disposal of the instant bail application. Call for the case diary. Call for the case diary of so. Case number so from the IO. The IO shall also be personally present before this court along with the case diary. Pending disposal of the instant bail application, the petitioners, you give the name, all the name, three names. are granted interim pre-arrest bail. The interim pre-arrest bail, the IO of the case is directed to release the petitioners on bail in event of their arrest in connection with the Nathiang PS case number so and so on the execution of PR bond of rupees 50,000 with two sureties of like amount, and on the following condition: number one, the petitioners slash accused shall appear before the IO as and when required. Number two, the petitioner shall not tamper with the evidence or influence any witnesses. The petitioner shall not leave the jurisdiction of this court without the permission of this court. The petitioners shall not make any press statements. Next one. The petitioner shall not make any press statements or comment on social media with regard to the matter sub judice in the court. The petitioners shall not make any inflammatory statements inciting the public. Fixed for CD and case diary. Fixed for the case diary and hearing. When? After 1 week? Anyway, you are protected. No. ठीक है.
Much obliged. Clear.
हाँ, good.